Hi everyone, Gene Richards here, attorney from the Williams Law Group, back on the Navigating DCP&P podcast, the podcast where we break down complex issues involving the division of child protection and permanency. On today's episode, we're going to discuss what are safety plans. What do parents need to know about safety plans, or really they're called safety protection plans. Before I get into these SPPs, or safety protection plans, I want to remind you all listening that any information that I share on this podcast does not create an attorney-client relationship, but we do welcome any person involved with DCP&P to contact our office for a confidential consultation with our team. So what is a safety protection plan? Well, it's a temporary agreement between DCP&P and the parent or parents, which is used by DCP&P to protect the child or the children. It's a way to try and put parameters in place to protect the child without having to remove a child from the home. Common conditions include supervision, no contact orders, and services being required. For example, DCP&P comes to a home, they're supposed to do whatever they can to avoid removal of the child or children from the home. So say there's an allegation of physical abuse, maybe against one, or let's just say both parents. DCP&P is concerned, but there may be a way to avoid removal despite being concerned. For example, having supervision in place, right? The parents perhaps aren't in a position, at least as per DCP&P, whether it's right or wrong, based on the allegation, again, just an allegation, but based on that allegation, DCP&P is concerned. And so DCP&P may say, well, look, we are concerned and we think the child may be at imminent risk of harm, therefore we have to remove the child. But if somebody can be in the home to supervise you, a grandparent and a neighbor, someone who is appropriate, then we can have this protection plan be put into place and can prevent a removal from happening. Or say just one parent is alleged to have done something wrong. DCP&P may say, well, look, if you leave the home or have no contact, we will not remove the children from the home. Or if the parents, if they agree to do certain services, evaluations, treatment, we believe that would be sufficient to not have to have the child or children removed from the home. So how are safety plans, safety protection plans created and enforced? Well, again, it's really an agreement between DCP&P, the parents, and really even the supervisors if that's the parameter of the SPP. And so there will be a form where it says, why is the SPP being put into place? What are the concerns? What are the factors that lead DCP&P to being concerned? And then what are the parameters of that protection plan, whether it be supervision, 24/7 supervision, certain services, no contact, a parent leaving the home, someone moving into the home to help supervise the parent or parents, and then who that is and their agreement to doing that. And although these plans, they have, you may say, good intentions, right? Trying to prevent removal doesn't mean it's appropriate. And the issue is that once these SPPs are agreed to, the family is really stuck with it unless DCP&P agrees to revoke the SPP, or you're in court and the court doesn't grant the parameters of that SPP in a court order. And I'll tell you what I mean by that, because there are risks and challenges to having an SPP put into place. It may sound great at first. If the option is to sign the SPP or have my child removed from the home, I'll sign whatever you want me to sign. And I get that perspective. But parents do need to fully understand what they are signing before they sign that safety protection plan. So as per DCP&P's policy, these protection plans are to be temporary and intended to safely resolve threats. Again, they're supposed to be temporary. In fact, as per DCP&P's policy, these protection plans are put into place for 10 days. And at the 10-day marker, DCP&P is either to revoke or lift the SPP, or take the parents to court to figure out if the court's going to grant the request revision parameters of that protection plan. But as often is the case, DCP&P can extend that protection plan really unilaterally through their own office or through counsel. It gets a little bit complicated, but I'll give a quick example as to SPPs and their lengths prior to getting into more detail about their risks and challenges of these protection plans. So say we go back to the example of there being alleged physical abuse, and I'll give you a clear-cut example. There's an infant. This infant has an injury that is unexplained. Could it be accidental? Could it be non-accidental? Well, we don't know yet. Everyone's just guessing. There's no evaluations. There's no in-depth medical review. And so in those situations, DCP&P says, well, parents, you're both caregivers of this child. This infant can't tell us what's going on. There's an injury. We're concerned. Therefore, we want to have you be supervised until we have more answers. And so parents agree to it. They have somebody come into the home to supervise them 24/7. And there it is. The SPP is in place. As you might imagine, to have a thorough medical review and evaluations, 10 days is not sufficient for someone to determine whether or not, based on their opinion, their medical opinion, is this injury accidental or non-accidental. The likelihood of having an opinion within 10 days is slim to none. And so right there, we know for a fact that this SPP is indeed temporary. It's not going to be sufficient to have the issues resolved. So either we'll be in court or DCP&P will have to lift it at that 10-day marker. But not so fast, right? In situations where parents have attorneys already in the pre-litigation phase, DCP&P's lawyer and your lawyer can say, look, we know this case relies heavily on reports and medical record review. And so if we go to court, just out of the fact that we don't know what's going on yet, the court's going to grant the parameters of the SPP in court order. So it's just going to be a copy and paste, essentially, of what's already in place. So why waste time going to court, being stuck in that process where this case relies pretty much entirely on the medical record review and the opinion of the doctors and the professionals? And so in those situations, the attorneys can agree and say, although this is a temporary agreement, a 10-day marker, we want to agree and consent to the SPP being continued and extended to avoid court. And then perhaps if we get the reports back, we'll know at that point court needs to happen or not. And so a lot of times in cases, 10 days, in fact, I feel like in almost every case I've ever had, 10 days is not going to resolve a case that involves an SPP. Usually there's more serious allegations. It's not a very open and shut case once an SPP is agreed to by the parents or by counsel to extend. So it's important to fully understand what you're signing, because the division may tell you, the worker may tell you, oh, it's temporary, no big deal, sign this. We're going to avoid having to go to court. We're going to avoid having to remove your child potentially. And this all sounds great when you're in some way surprised by or ambushed by a worker coming to your home. It sounds great. Based on what could be, this isn't a bad outcome at this time. And you might be told, oh, we'll have answers to you in a week or 10 days, and this will all be resolved. In fact, I've had clients, parents told, oh, it's temporary. We'll have an answer for you in 7 to 10 days, and this will be lifted most likely within 7 to 10 days. And then the SPP was in place for several months. So you got to be careful and fully understand what you're signing, because you're being told one thing, which most likely is not accurate. And once you sign the SPP, you're now obligated, responsible to follow that protection plan. Even someone who's supervising you, right? There's consequences for both the parents and the supervisors in violating that protection plan. In fact, I've had a client come to me who was a grandparent who was a supervisor under the SPP for her daughter. And there was evidence that the grandmother did not follow the SPP and allowed her daughter to have unsupervised parenting time. And based on the grandparents' violation of that protection plan, she had to hire me to appeal a finding of abuse and neglect against her. Based on her violation of that SPP, she was substantiated. And so there are dire consequences for not just the parent, but also the supervisor in violating that safety protection plan. because if that person is responsible for supervising a parent who is deemed to be potentially a danger or unfit by DCP&P or the court, even if it's just for 5-10 minutes, which, that's still unsupervised, that may be enough to have DCP now make that grandparent, that supervisor, a target of a DCP&P investigation and then a finding of neglect or abuse. And safety protection plans also can delay a case. And I'll tell you what I mean by that. I mean, I've had cases where we push back and say, no, we're not signing anything. We believe that DCP&P is overstepping. They are exaggerating the case as a whole. Let's allow for things to come to light prior to having these restrictions be put into place. Because once you have restrictions, right, supervision, agree to services, that then can delay the case as a whole. Now, while SPPs do prevent removal per se, it still can delay the case as a whole by having you be supervised, having to lift that restriction, having to do services, having other individuals involved in the case. All these different factors can delay a case. And so if you cannot just avoid removal, but avoid a protection plan, then that is obviously the way that you want your case to go. Now, these protection plans, I discussed already a bit about the flaws of these protection plans, because again, you're being told by a worker it's temporary, which it is, but what's temporary mean? Do you mean the actual 10 days? Do you mean 4 months? Do you mean we're going to court in a month? Or what's temporary mean? It's not really a clear-cut guideline because that 10-day marker isn't statute. It's a DCP&P policy. And they don't follow their own policies. It's not a state law. It says a DCP&P organizational policy. And so a lot of times parents sign something thinking it'll be over in a week, and they find themselves in court in a week instead, or in a month or two, or never at all, but have an SPP in place for 3 months until DCP&P conducts their investigation. And so once you agree to the SPP, it almost buys DCP&P time, which they sometimes need. I get that because cases are complicated and it takes a while to get records and evaluations that may need to happen completed. But in those situations, basically you're granting DCP&P an extension almost to say, all right, don't have to file a complaint, don't have to go to court. These parents have already agreed to kind of be stuck in our grasp and stuck in our investigation. And so by doing that, litigant, and you're not really a litigant, you're not in court, but you give them almost the leverage and the power to conduct as they please. And so it's important to understand what you are signing, but also have an attorney on your side to push back with DCP to expedite their process so that once the SPP is signed, if it already is signed, to have that case wrapped up as fast as possible. So I'll tell you what we do, all right, in these cases, because sometimes reports and records do take a while in a lot of cases. So you sign the SPP. I'll give you another example. It's really one that has SPPs last a long time when you have an infant injured because it's hard to tell what happened. Babies get hurt, accidental, not accidental, no one's sure. It takes a while to be sure of that. And obviously, being cautious in those cases it's what's going to happen. And so you sign an SPP. We're waiting for records to come back to determine accidental versus non-accidental. And it can take 1, 2, 3, 4, 5 months. But it's important in those cases to have a lawyer continue to reach out to their attorney, DCP&P's attorney. It's important for you to give your attorney different records, maybe get your own evaluations done, your own reviews done to provide to the division proof of saying, hey, well, while waiting for your records, we have an expert here saying it's accidental. A clear example of this is when I've had proactive clients and parents who have kind of followed that advice and done things. It cut the SPP in half, if not more than that, by providing DCP&P with records themselves, with separate opinions, by being proactive, by doing DCP&P's job for them, which is what needs to happen oftentimes, but having your lawyer push back and have those things happen, it can cut the length of the SPP down, even in those specific and severe and difficult to prove either way cases with an infant being involved. It can cut that SPP length in half, if not more. And so it's important to know what can be done through your counsel, through your own kind of being proactive in these cases to have cases wrapped up as fast as possible. Because the goal as a family is always to really, and as your attorney, is to figure out how to get DCP&P out of your life as quickly as possible. As always, I want to thank everyone listening for tuning in. for learning, for obtaining information, because whether you're in a DCP&P case right now or you aren't, you may know somebody who is or who will be. And having information allows you or your friend or family to better address a DCP&P issue in a case. And so we discussed today issues of SPPs, safety protection plans, what they are, how they're put into place, how important it is to know what you're signing, and how important it is to have an attorney push back, and also having yourself be proactive in addressing the DCP&P issues and concerns. Now, as always, I want to ask everyone here who's listening to subscribe, to share with your friends and family, and tune in each week. We have resources and support on our website, on our social media pages. Although we do post the podcast once a week, we also have different postings done throughout the week with information, with other reels and videos, with other information and knowledge for you to obtain about DCP&P matters. Now, although I do focus, as you can tell, based on the title of the podcast, on DCP&P cases, obviously DCP&P cases do become entangled with matrimonial matters, custody matters, and also domestic violence cases. In fact, oftentimes, if there's a domestic violence case and there are kids in the home, that by itself alerts DCP&P and causes them to be involved. So on next week's episode, we're going to discuss domestic violence allegations in DCP&P cases. How does DCP&P cases, or how do DCP&P cases affect domestic violence cases, and vice versa? So please tune in next week about that, about DV cases and DCP&P cases kind of intertwined. But until then, please have a great week and be safe.